Morning. It's good of you to be able to join with you. I think Vincent, we have gone back quite a few years, and he asked me to at least share with some experience you have to on the tenancy agreement, which is I think that's coming up. I mean, there's a lot of tenancies, and there are a lot of hurdles here which are not so common. At least from all the feedbacks I get, feedbacks from agents, feedbacks from tenants, and what seems like normal to them or a lot. It's not so commonly well known, and I'm just going to focus more on the legal part of it, which is not so addressed usually when you sign a tenancy. Because people usually sign a tenancy, you like a place, you sign it, and you stamp it, and that's it. No, usually you just move in and not wanting to be too concerned, and only when you come into issues, then you realize what are all these for, and perhaps I can just give you a backdrop. Maybe we can start off with, I think that's Vincent has already collated some of the points that seems to be feedback that you want to address. I think we have the agenda here, and perhaps the next one I'll start off with stamp duty. The stamp duty. I think when you realize that any of you might have wondered why when you stamp or you sign a tenancy agreement, hey, what is the stamping for? Is it just so that you get the government gets that to pay taxes? No, can we don't stamp? There's a lot of all these old tenancies where they say that, oh, after so many years, forget about tenants, forget about stamping, just go ahead and just continue, and as long as I get payment, that's fine. Well, there are some. Let me share with you what's the legal basis for stamping in the first place. The stamping, if without stamping it, some people ask me, is it valid? No, doesn't mean that if I don't stamp it, it means I'm not valid. Well, not true. The purpose of stamping is so that it can be submitted as evidence in court. So if you really want to enforce it, if you don't stamp it, you don't have a contract to show for it. So if it ever goes to court, you need to stamp it. The stamping wise, don't worry, it can be stamped anytime. There is a timeline later on, when it must be stamped is 14 days after the date of the agreement. Now, after that, if let's say you forget the stamp and then you stamp it maybe half a year later, now, okay, well, it's okay. You get a bit of admin. I mean, there's administrative late penalty. That's fine. I mean, it still can be stamped. So any tenancy agreement can be stamped anytime. So not to worry too much about it. So, okay, now with the stamping, does it benefit the tenant itself? Yes, it does, because then it is once the agreement is stamped, it becomes a contract that can be admitted to court and can be shown as a contract. So you need the fact that stamps. And also there's a more practical view. I mean, this one not so much for a tenant, but some of you say, oh, perhaps trying to save stamp duty for the landlord, but you or the tenant, and you say, okay, you only when I want to enforce it, then perhaps then I'll stamp it. But not true, because everyone has a bank or refinance, have a mortgage bank loan. If the tenancy is not stamped, if the landlord was to go for refinancing or to sell the property, then that's where they're going to become an issue. For sure, when you sell the property and there's a tenancy, it must come with a tenancy with the stamp cert. There's no such thing. If you didn't stamp it, you just end up having to stamp it there and then. And if on the background for the landlord, when they do I mean, everyone does a refinancing every 2 years, and the banks will require evidence of this stamp certificate. Why they require it? Because it's part of the security that they enforce, that they have able to write to the tenant and say, hey, if the landlord don't pay the money installment, the bank can actually write to the tenant to say rental to be given to the bank. So this stamping is also a requirement. It's also a requirement by the bank. So there are a lot of things that when you sign a tenancy agreement, you don't that there are consequences that the landlord may not have known there and then so that is why they need a tenancy to be stamped. Always has to, and practice has it is that the stamping, I mean, under the Orange Tree tenancy agreement, which is also in line with market practice, is that the tenancy has to be, the cost of stamping has to be borne by the tenant. Okay, so that's the basis of why we have stamping. So I'm going to, I mean, if I will pause here, if because there are some legal concepts that gone in with the banks and all that. So if you want to field any questions, please type it to Vincent before I move on to the next one. So if you have any, please, Vincent, let me know before I
Yeah.
move to the next slide.
Yeah. Okay. I will just assist because I think it's difficult for you to read the question. But I see one question. That's from Thomas. He was asking, so fully pay up property landlord don't stamp it. I think just now Gary did mention something like if let's say the landlord even fully pay out, they want to get a term loan, equity loan, they want to show proof of that they have this tenancy and they are receiving this income, then they should stamp it because without the stamping, the income generated from the property is not recognized, right? Gary, you want to talk more about it?
Oh, okay.
There was some question.
Okay, when the income of that's too, yeah, well, stamping, yes, is in line. Whether the IRS and the income tax talk to each other, well, we'll let you all decide whether they do. My chances are, I think they do. When you declare the income. So if you declare an income for this fully paid up property, they whether they check and then they'll fine you, they don't police it that well. I mean, the IRS is not going to suddenly come to you and say, hey, you have a tenancy agreement that you didn't stamp. No, they don't do that. But Vincent, you're right to mention that even fully paid up, you will probably declare your tenancy agreement as income, and that will reflect somewhere in evidence that there will be an ongoing tenancy. So yes, but not stamping it is it's if it's who's is it, why do you not want to stamp it to save money for the tenant? Well, maybe, but then again, when the tenant doesn't pay and or the tenant suddenly is have a dispute with the landlord on what are the terms and what are their rights, then how does that not stamping, then the non-stamping issue comes up. Because if you don't stamp it, you can't enforce it, so to speak. You can't bring it to court as evidence. Whether it reaches that stage, the different matter altogether. But without stamping it, and then you have to stamp it, then you pay late stamping issue, stamping admin fee. So yes, there is a risk. If it's fully paid up, you don't want to stamp it, then you run the risk that it cannot be submitted in court. It's not stamped. Yeah. Okay. Any other questions, Vincent?
No, I think it is okay. And I think Grace asked, is there a fine for late stamping? Yes, there is. Yeah, it's
Yeah,
a
there
late
is.
payment fee.
Yeah,
The
there is.
details you can find on IR's website.
Yeah.
So
It's a very complicated way of calculating it. It's
yeah.
not just a straight 3% late interest. They have it at a different rate. So it's not that much, but it's something to take note to.
Okay. Okay. Must it be submitted to them?
Next.
Yeah.
Okay, this option to renew. I get a lot of whenever I do the transaction or review any lease agreement, one of the main things that people want to have a look at is option to renew. A lot of people think that this option to renew is that something you all talk about, something to negotiate, and then if you want to renew, both parties must agree. While that might be true in most of the options, there are actually two kinds of options to renew. The one that is typically found, let's say in the orange tea, is that they, I think about 3 months before or a certain number of months before that the tenant will approach the landlord and say, hey, I want to renew, let's talk about it and let's see whether we can work something out. Well, that's the typical option to renew clause, but that's not always the case. I've seen quite a few, I mean, not so much nowadays, but those that that want to stay longer, so they have 1+1 or 2+2, and this option to renew is actually what you call a binding option to renew. Okay, when you say binding option to renew means, what does that mean? It means that if the landlord suddenly says that I want to extend, and then the landlord got no choice but to lease it out, I mean like no choice because it's bound by the contract. Okay, so this, when do you see how do you differentiate within what you see normally in the orange tea one and let's say the others, and also something for you to consider if that is one of the concerns of the tenant. I mean the landlord will never want it. It's always at the request of the tenant because it's entirely in the benefit of the tenant. And this is where there's a similar clause just like that, except they say either both parties agree, and if they cannot agree on a rent, then this new term, I mean, things are going to be fixed, is that it has to be renewed for a certain X number of years. Means, let's say 2 years, and the rent, if they cannot agree based on market rate, they will, one, either cap it at maybe 10% above the previous one. Means if they cannot agree, then it will just increase by 10%. And if that is the provision in the clause, that means there are few things that are already certain. There is tenure, means the length of the renewal is certain. It cannot agree on the rental, is capped at this amount. Once you have these two factors in, it's a binding option, and the tenant can then just, okay, I want to renew, and there's nothing the landlord can do. Yeah, so that is important, especially when the landlord have other feels that they can find better lease, or they want to use for themselves, or they want to sell the property, and suddenly they want to sell, and the buyer of the property wants it to stay, then that becomes a real issue. So this option, that just to take note that there are such an option out there, and not every option is a non-binding. I'll just agree on each other's price, and then we leave. I mean, there are several permutation, and then if anyone has comments to want to explore further on these options, before I move on to the next slide or at the end of the Q&A, they can ask me. Then I will explain more on this clause itself. Okay. Okay. This is okay. A non. Okay. This is mentioned here about replacement and novation issue with COVID-19 related. This is something that was fielded by people asking. When you say replacement, you're talking about, people, if circumstances now, they have lost their job, they have to then break lease, and they ask for find someone else. Unfortunately, for the COVID-19 situation, while we are all very sympathetic it is, the law still stands at this. I'm talking about residential leases, just residential. And for residential leases, the government has not stepped in, and they have held the view that it's still based on law. So if you have lost your job, and if you have no diplomatic clause and all that, the typical fixed lease still applies. The rule is that fixed lease still applies from the legal perspective. And whether they find another tenant is up to the landlord, whether they are agreeable to take on this tenant. It doesn't mean automatically. A lot of people think that if they find another tenant and it's at the same price, why would the landlord not agree? There is a lot of landlords hold the view that I contracted with you because I profiled you as a tenant, and I'm okay to enter this contract with you. Doesn't mean just because you find someone else that I'm okay to enter with the other person. Because more and more people nowadays, they are concerned about how the tenant will be able to pay, and then also whether they take care of the place. Because 2 months security is just something not enough if they really go don't take care of the unit itself. And a lot of landlords is beginning to prioritize, that I'd rather have a stable tenant paying than one that at the higher rent but pays 1 week, 1 month, and then have to chase, and there's not gives you more problems like that. So that is still not a given as long as you actually find someone to replace. It is still the landlord's decision, even though it has to be tempered with a bit of principle of reasonableness. So yes, you can. I would suggest, instead of a novation issue, for everybody's sake, I think the new tenant should just go and re-sign a new tenancy agreement. And all these costs for having to find a next one and all that should be placed on the tenant existing. Okay, just so we're clear, what's the basic law when you enter in a fixed tenancy agreement and the tenant breaks it for COVID-19 or any other issue? It doesn't mean that they just forego the 2 months and walk away. Not true. The basic principle under the law is that the landlord, if let's say within 2 years they stayed 6 months, it's still 1.5 more years, then the landlord got to go and look out for replacement tenant. All this cost for finding to replace it is supposed to be borne by the tenant. If after trying to look as much as it can, he found a tenant with rental lower, the exiting tenant, the one that breached it, must pay for the difference throughout the whole period and the end of his contract period. So that is the basic position in the law, that he has to make good for the loss itself. If of course he finds a better tenant, the landlord makes a better tenant, and he makes he earns more. I mean, obviously the tenant doesn't, the existing tenant don't get to benefit from it, but that will be what the basis of the basic principle of law. It's always been like that, and so I wanted to tell you to clarify this principle, because I noticed that I know on a practical basis, enforcing that is also a big hurdle. But and a lot of people just take the view that just take the security deposit and move on. Well, maybe yeah. While that is in practice, but that's not actually the basis of it. Or I have people holding the view that, oh, you break the lease, right? Okay, then you will have to pay the entire 1.5 years. Entire 1.5 years, and while I find another tenant, and that tenant is on top of the what I get to claim against you for the 1.5 years. No, that's also not true, lah. You only get to, you cannot. There's a principle in the law that you cannot benefit from it. It means take two takes from two rental from such situations. The law is supposed to put you back in the position where you were as if the contract didn't break by the tenant. Okay, that's quite a lot. So I let you all digest of it.
Yeah.
Maybe the next slide.
Yeah, maybe before the next slide, maybe there is a question. I don't know if it's going to take you another 1 hour, Gary. One of our salesperson actually asked, what is the difference between novation and assignments? Do you think you want to answer this?
That one is quite legalistic. I would say that it goes into legalistic, and my take is that when it goes to assignment, because assignment can go into only do the assign the rights but not the obligations, then while novations is a little bit different. So I wouldn't go that. I can take it offline for that, I think. And usually when assignment and novation is hardly done nowadays, I wouldn't suggest you do it. I really don't. I mean, even in the situations of where you find a replacement tenancy, a tenant and all that, I would suggest to sign a new one, because that involves, chances are is that if you have a novation or assignment, it's going to entail signing the previous tenant. So you should clear out everything from the previous tenant while you find a new tenant, and the new tenant comes in clean. Otherwise, there are situations where you step into the shoes of the previous tenant, and that would have a legacy of liabilities that come along with it. So, but anyway, I think that's a good question, because that's a more legalistic question, and that usually happens not in your day-to-day residential tenancy agreement. That happens in more the multinational lease agreement, where you lease out entire buildings and things like that. So I wouldn't want to touch base on this, but can do it offline. Yeah. Anything else?
Maybe the rest we can you can answer it later, because I think
Okay.
now we finish the slide. Next.
Okay, this is I think it's a hot topic now. I get a lot of people now with non-payment of rent. Okay, this is again based on residential, and the residential meaning is based on business as usual. Business as usual as previous before COVID, meaning you sign a fixed term contract and you're supposed to pay for it. Now, under the tenancy agreement, you have a non-payment of rent is actually a material breach. But I know a lot of people, when you breach it, they'll call the tenant, wait 1 month, by time 2 months, and then you try to then work out something with the tenant. But from a legal perspective, once they don't pay rent, you have to decide. Okay, you have to decide that whether you want to consider this as a material. The landlord got to decide. The landlord got to decide whether they want to consider this a material breach, because if they do, and it's provided in the tenancy agreement as a material breach, and if they do a material breach, then the landlord needs to decide what action do they want to take. Okay, of course, most practical one is to try to talk to the tenant and say what's happening. You have, and then sort it out with them. and then hopefully they pay later. But if suddenly the tenant is uncontactable, like uncontactable, and then what do you do? Then you says okay. If it's really true that they can't be contacted, then you ask yourself, do you want to terminate? What do you want to do? You want to terminate the tenancy agreement? You want to have a letter of demand against the tenant? Yeah, all these are possible. My suggestion is that from besides the practical approach, I know a lot of people just call WhatsApp. If not, I'll try to go and lock up the place itself. Well, we'll touch on that a little bit more. But for non-payment of rent, it's a material breach, and it's a breach that the landlord can terminate the lease. So the landlord, if you want to actually take on this right, they must inform the tenant that they want to terminate the lease. So, but of course, they want to collect the rental first, lah. And I think from that perspective, you should try to reach out to them, remind them, send a letter to the tenant saying that they have not heard from them, and to actually that they have a material breach. You have considered they have a right to terminate the lease if not this payment is not made. Once you mention to them already, then you don't need to engage a lawyer for this. I would suggest that the tenant go and just write a letter. Don't just WhatsApp. If you want to do a letter, I mean, nowadays I know a lot of people just drop emails and WhatsApp. It's possible. But do note in the tenancy agreement, the addresses of communication is still based on the address that's mentioned there. So if you know the tenant is staying at your place, make sure that you post it there or slip it underneath, and then you scan the letter, WhatsApp, and send it to him. Make sure that an email. So make sure that you don't have a situation where the tenant said that, oh, sorry, I lost my phone, I changed my number, and that's why I couldn't contact you, or I was under quarantine overseas, and then 4 months later I came back and realized that you have broken in and sold all his stuff, and the new tenant is staying there. Then he said, hey, I have a tenancy agreement, you never contacted me. I was due to compliance to another country's laws. I was staying there, and I couldn't reach out to make payment to you. So that's also an issue that you will face. So you must make sure that you get a direct some kind of communication going with your tenant itself. Okay. 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 This diplomatic clause is okay. Let me explain what a diplomatic clause is. A diplomatic clause typically is a get out for it's purely for the interest of the tenant again, where maybe they sign a 3-year lease or 2-year lease, but they actually wanted to just play safe because they know that when they sign in any tenancy agreement, it's actually a fixed term. So this diplomatic clause is typically after 12 months that then the tenant can actually serve a notice to the landlord, say, hey, I want to get out, based on the fact that I no longer work in Singapore, and you must show evidence, and they give a notice of 3 months. So that's what the basis for diplomatic clause is for, where the tenant can terminate so-called the lease after fulfilling the initial 12 months. You can be 12 months or any arbitrary number, and the notice to give to the landlord also can be fixed under the Orange T tenancy agreement. That's all these are variables, but I would say that typically it's after for a 2-year lease, it's typically after 12 months, and then notice to be given 2 months. 2 months or 3 months. I think more so 2 months after the 12 months period. So that's what a diplomatic clause is on. If no details, we move on to the next. Okay, this one. Now we're now going back to more nitty-gritties, and this is when after your tenancy is signed. Now I'm just going to backtrack a little. I'm assuming that when you have a handover, a tenancy agreement, there's a joint inspection, there's photos taken, there's burn the CD-ROM or thumb drive or email across when you hand over. There's a list of existing defects, scratches, anything on the wall. So all this will be reported, and that will be exchanged within either through the agent or through the tenant and the landlord itself. So there is a baseline of how the property was handed to the tenant. Now, okay, when this is minor repair cost and covers replacement. Okay, I read the Orange T tenancy agreement, and it's actually a very comprehensive tenancy. I feel that's actually quite good. It provides a situation where uh, you hand over. There's 1 month. I mean, or at least there's a month, or typically it's 1 month where the tenant can look at everything, and while he stays there for 1 month, report anything that's spoiled. You know, that's it does protect the landlord and also gives opportunity for the tenant to voice any issues. Because sometimes when you just visit, cursory look at everything, it's hard to discover it straight away. So there is a period, what you call a period where the tenant can raise any issue to the landlord. So after this period, then okay, then there is a minimum cost where I think anything that's broken, then it will be usually it's $150, $180. The initial $180 is like excess of insurance that the tenant has to pay first. That's what provided in the it's not a automatic right. It's actually only if it's provided, and it is provided in the Orange tenancy agreement that this is how things are supposed to be done. So it's good, you know. Now this minor repair cost and replacement, it's literally supposed to be for everything, that is but it's for everything that is that comes to that needs replacement. Now, okay, there is also a situation where some people ask, hey, what happened about the aircon? It's a 10-year-old aircon and the whole compressor breaks down. Doesn't mean that I have to pay for all these. Okay, it gets a little bit more vague, I mean, on default, the Orange tenancy agreement does provide that everything sort of fair wear and tear, it's supposed to be borne by the tenant. What I mean by borne by tenant? Okay, it gets a bit the mechanics of it. If it's normal, something that's broken needs to be replaced, excess, $180. Okay, you put out a big number there, $180 paid. The rest, the landlord got to bear. But it does provide also that if it's due to the sole fault of the tenant, then it's silent. But I think it says that then the landlord doesn't need to pay for the whole thing. It doesn't say that landlord will not pay, but just say that it's silent on this matter. Why it's silent specifically is because if you have a aircon where compressor was already 10 years on its last leg, and suddenly it breaks down, then you have to see whether it's fair wear and tear. This concept of fair wear and tear, where you see throughout the tenancy agreement, is so that the poor tenant don't get laden with a big bill when it's an old thing, and then the landlord get to benefit from buying a new compressor or a new fridge, just because you're the last one to use it and it completely breaks down. So that is where the fair wear and tear concept to protect both parties. Now, fair wear and tear is very subjective, and I know it's always very contentious because they have two sides of a coin. Landlord thinks that their things can last for 30 years, well, which it doesn't, obviously, and then the tenant, though. So it's good that if cannot, no, like everything else, get an expert to have a look at it. After all, you got to get an aircon guy to come in, and then you go get a fridge guy to come in, or a heater, and then you just see whether the parts were worn out. It's just due to age, or you have to see what the cause is. So it's best to get a third party to have a look at it, and see from there. Then you can lean whether it is to any fault and any individual, or is it to just normal wear and tear. Yeah. Oh, one more thing is that I saw another question here. Like, can a tenant get a locksmith to break open the lock after she has lost the key in this current stage? I believe this is a situation where I think that the tenant was away for quite a few months, came back and couldn't locate the landlord. My take is that, well, you have not been evicted out of your tenancy. That's where I caution you that you don't automatically lock someone out. Then you are technically a tenant of a place, and while you're supposed to ask the landlord for consent, but if you try your best and you cannot contact your landlord, then yes, by all means, engage a locksmith and access your property. I mean, you lost it, then you have to pay for all this. I mean, that goes without saying. But to answer succinctly your question, yeah, you can engage a locksmith to attend to this. Yeah. You have another slide?
Sorry, Gary, can I just check with you one question first, because we received like 4 or 5 questions regarding diplomatic clause. So
Okay.
maybe you can share with us for diplomatic clause, right? For one issue is that who does it apply to? Is it to the foreigners only, or to work permit holder, to student pass, or to expatriates or things like that? So is there a specific group that this diplomatic clause applies to? I think there were 2 questions on this. Is it only
Okay,
foreigners eligible for diplomatic clause? Yeah.
let's have a look. Let's have a look at your diplomatic clause in your Orange
Yeah.
TA itself.
And also, I think there's somebody asking that if there's a for foreigners renew this, does the same 12+2 diplomatic clause still applies? Okay, for what I understand, but maybe Gary, you can tell us more. For what my understanding is that diplomatic clause only for the first tenancy. Subsequently, they already fulfill the first 12 months. There isn't a 12+2. You cannot say that always renew this 2 years, then you 12+2, 12+2. No, right, Gary?
Okay. Okay. When you renew a tenancy agreement, when you just, let's say, refer to the previous tenancy agreement, and the tenancy is going to extend for another 12 years. No. So now, I would say that when you do that, you should actually mention that the tenancy is extended or is renewed for another term on the same terms and conditions, with the exception of the diplomatic clause. You should carve it out. You should just mention that it's carved out, so that you don't automatically, because you see, when you extend it based on the same terms, then you actually mimic and give the tenant that diplomatic clause again. Yeah, because it becomes 2 separate agreements. You see, one agreement, you finish the term. The next extension, you actually say on the same terms and condition, because you will have to say the same term. You will mention the rent is this one, and all other terms and conditions to remain the same. Typically, that's what you say in the renewal letter. And so when you say the same terms and conditions, you actually then copy and give the tenant that right of diplomatic clause again. So it's better to, when you say the renewal, to say that, just say with the exception of the diplomatic clause, all terms and conditions are to remain the same. So then you can, that'll be better. So with regard to your question, based on your diplomatic clause, I think this is the black. Okay, usually the diplomatic clause is actually meant for foreigners when they get to leave or break the lease when they are no longer employed in Singapore. That's why that is a usual diplomatic clause, and it applies to foreigners or employees. I mean, when you're actually foreigners and they're studying here. I mean, not studying here, sorry, working here. Now, if it's going to be students, then this has to be slightly changed. You cannot, I mean, the words here of they are being employed here got to be changed. It's all possible. I mean, if a bit of tweaking, you can just put it as a student. If they are no longer studying in Singapore or whichever reason, then you just say that they must show evidence that they are no longer in Singapore and they have to leave. So that also can be adapted. But just this diplomatic clause, based on the one that is on Orange T, it will be that it's meant for foreigners working here, because it provides for evidence of from the employer that they are no longer working in Singapore. So I hope that answers your question. Yeah.
So it doesn't apply to student pass, right?
No, it doesn't. Yeah, but can be modified, lah. Yeah, but it doesn't. Yeah, not with the standard this current working.
Thank you, Gary.
Okay. Shall we go to the next slide? okay, this is a tenancy agreement. Okay, this is now just a general feel of the tenancy agreement. Before we close up, okay, for tenancy agreement, I noticed that there are a few things that you have to take note. This is more practical and also has legal consequences. First, you must date the tenancy agreement properly. And then when you stamp it, please date it the same. I mean, when you stamp it and you put the date of the document, please ensure that the date in the tenancy agreement also reflects for the date of the document in the stamp cert. All these are technicalities that after when they have to relook it, it actually had to be amended. Fill up all the details. I noticed as a practice, please remember to get both landlords to sign on it, and not just one landlord. It'll be better that you get both landlords to sign on it. And witness will be good because usually the banks will require it. But without a witness, is it still legally binding? Yes, it's still legally binding. So that's not so much an issue. And regards to the security deposit, the offer from the what's the purpose of legal of the 2 months or 3 months security deposit? That is actually meant not to cover rent, but it's actually meant for the handover should the place not be up to scratch and there needs to be redone or to do up the place again if the tenant wasn't taking care of the premises itself. Now, so the security deposit, while a lot of practice use it as a rental, but technically that's not what it's supposed to do. Just so that why I'm mentioning is that I don't want the tenant to just automatically assume that they have a right that this security deposit can be covered for their outstanding rental. So while the landlord may give that as a concession, but the default position under law is that they're not at all permitted to. So if they are 2 months overdue for rental, they say, never mind, you got security deposit. So what have you lost? No, by law, they have breached a material breach and they have to pay. And the security deposit is security deposit, not at all supposed to be net off as rental. Okay, I'm just going to go through.
I'm so sorry, Gary. I think there are too many questions that's coming in. So we may or may not be able to answer all today. But just
Okay,
now,
no problem.
I just saw another question is regarding the, he just want to confirm that for foreigners renting in Singapore, it's not recommended to put a lease that's more than 7 years. Is there such thing like this?
Yeah, don't do that because no, I've not seen any leases that are more than 7 years because that creates an interest over the land. So don't do that. Yeah, I mean, if you want to do that, you want to do a 3 years or 4 years plus another binding option to renew. So no, but no, do not do a 7-year lease. Yeah, in fact, I don't know practically anyone wanting to do that. Yeah, but no, there is some legal implication to it. Anyone that's leased that for more than 7 years, they tend to have complications and they entrench themselves having some interest over the property and the stay itself. So don't do that. Yeah, you're right. Yeah.
Sure.
Okay.
John can go to the next slide. Okay. I think there are just too many questions that are flowing in, so we won't be able to answer every one of them now because, as I mentioned before, a lawyer is not cheap. So I'm just joking, but there's one way here that you can always email into info@tcglaw.corp.com. Okay, and or you can call the law firm that Gary is from, TCG Law Corporation. The number is above. Okay, so for those people who are watching it now, maybe you just take a photo of this, and there's any questions you would like to ask, okay, you can actually divert to them. Yep. And
I
or
think,
you can.
yeah. I think what we'll do is that I think because this is I think you can collate your question and maybe with Vincent. I'll be happy to have another session if it's just on specific questions. Yeah, so that it's I can address it and then
Sure.
go down the list of specifically. Yeah, because
Sure,
sometimes I don't want to. If you email me, I scared I'm in meetings and things like that, so I
yeah,
don't respond to you. So I think a better approach will be, Vincent
I
has
will
been
collect it.
organizing this perfectly, so I'll be happy to come back here again if anything.
Okay, and also to answer to some of the questions here just now, they were asking not because today we are talking about tenancy per se. So there are people asking about ABSD and things like that. Then those questions I think will be answered later on as in another session, not today. All right. So today is only focusing on tenancy agreement. So basically, I will copy down all the Q&A here, okay, and then consolidate it and see any repeat questions. And then with that, I will pass it to Gary. I will do the consolidation for Gary, as what Gary's mentioned. Yeah. So don't feel bad that if let's say any of the question that you put down here is not answered by Gary. So Gary, do you have any last few words with us to tell us?
I think it's
Encouragement.
okay. No, I think times now are actually quite tough. I mean, I see a lot of them, having to make practical compromises on the situation. There is a lot of fear out there when it comes to tenancy. I think the only good thing is that the landlords are also beginning to be a bit more realistic in the pricing, realistic that it's tougher to find tenants or to any secure. Every time I get a sale file, I always congratulate the owners because it's not easy, to secure a sale, to maintain ascertain a sale. But the last couple of months, there's a surge in activity, so that's very encouraging. Maybe it's pent-up demand, but we are getting quite busy, so it's a good sign, of things. Yeah, I hope to be able to all your questions that you have. I'll be happy to answer them, but perhaps in another session like that. No, perhaps not individually, but maybe in a session like that. I'll be happy to do that.
I get what you mean, Gary. Yeah, sure. But anyway, to all our Orange Sea partners, buddies, okay, don't worry. PCS is going to be here every Wednesday. So we were going to invite all the lawyers back again. And then if there's new topics, so that means if there's a specific topics that you want to find out, you can always email to learningorange.com as well. So pertaining to what Gary had mentioned just now, maybe you can email to learning@orange.com as well. So we will consolidate all your questions. Besides what is already here, the Q&A here, we have like 50 plus questions here. So I will consolidate it and then pass to Gary as well. So I believe that comes to the end of the session today. Gary? Okay.
Yes.
I just want to say thank you to you. Thank you very much.
Okay.
Yeah.
No.
So we'll end the session today.
Okay.
Thank you, everybody. Thank you.
All right.
Thanks.
Thanks.